Bill Hartgering. Most of my practice is as a mediator. After practicing for almost 7 years, I decided, after trying different kinds of litigation practice with different firms, that I didn't enjoy litigation. A lot of cases were settled on the courthouse steps without anybody having a chance to talk about the case or have any chance to be heard by the other side. I do a lot of conflicts involving a lot of big emotional issues. I think you do your homework and you find out beforehand what you think those obstacles really are. And you know about those before the parties get to the table. I spend a fair amount of time trying to get them to have a discussion of key issues where they're able, and I provide some coaching, they're able to talk directly to each other. And so if I know I've got an issue, I ask, and I want to have the party to be able to tell their story, but all of the understandable anger that somebody has, not whether they're right or wrong, but the anger is just there, that can be assuaged beforehand, and the person can feel heard. I mean, I'm good at listening, and I'm good at asking questions, and that makes a big difference, because often in cases, even in big corporate cases where they've been litigating for years and they've spent over $1 million, by the time they get to mediation, they've not spent much time talking about this and talking about stuff that may be really driving them other than money. The parties get to be in a situation where they really get to control what happens. Mediators can create mutual gain, and that can happen. You can get something and I can get something. There are ways that you can find out about things that both sides might want, having nothing to do with the underlying dispute, but things that can be provided, more than ongoing business and all the obvious ones. And if you can come up with those, people walk away really happy. And really satisfied. Happy is the wrong word. They're not happy, because but there can be a lot more satisfaction.